Welcome to the February 2015 Food for Thought Education Series. Today we will be discussing labor law regulations. Our speakers today are Peter Wingate, the Deputy Director of the Colorado Division of Labor, and Todd Fredrickson, a Managing Partner of the Denver office of Fisher & Phillips Attorneys at Law. We would like to say thank you to our Food for Thought Education Series sponsor, Pinnacle Insurance. We'd like to ask you to hold your questions until the end of the session. For those on the webinar, in the bottom right-hand corner, you will see a chat box where you can ask questions. If you only see a plus sign, click the plus sign and you will be able to see the box. For those of you that are here in person, please raise your hand and we will repeat your questions so that those on the webinar can hear you. I will now pass it over to Andy, who will start the session.
Good morning. It's my pleasure this morning to serve as the moderator. I don't think we'll need that. Okay. On labor law. I've taught and done some research and consulted in operations and human resources, labor relations, while I was at the University of Denver, where I'm now Professor Emeritus. I'm also a Director Emeritus for the board of the CRA, which really translates into I'm old, and therefore have been able to observe and comment upon the role of government relative to the Department of Labor and the National Labor Relations Board. It is my opinion that at the federal level, there is now a more hostile atmosphere towards business than I have known or studied about in the last 70 years. We are fortunate in Colorado to have a labor department that is more open and helpful to business than that at the federal level, which is not meant to imply that they are not tough on those who do not comply with the law and regulations, only that they are willing to help clarify those laws and regulations rather than having a penalty as a first bit of mentality. The industry is facing a seemingly endless number of challenges at both the national and local levels. Business is good. That's good news. But it is a caveat of a tighter labor market, which will have an effect upon the availability and the cost of labor going in further into 2015. We have an active and hungry plaintiffs bar with a local firm, Bacchus & Schenker, which is involved with a lawsuit directed at Chipotle, charging non-payment of overtime. And they are seeking a collective action status to open a lawsuit to the restaurants, the national workforce. We have a president advocating for higher minimum wage and for paid sick leave, as well as supporting a much more active National Labor Relations Board and an update of the Fair Labor Standards Act relative to the classification of workers as either non-exempt or exempt, and increasing the salary base for exempt employees. On the state level, we have a wage theft law passed by our legislators that went into effect on January 1st of this year, which we will hear more about during the program. To help us understand our responsibilities under the law and regulations, we have two very qualified individuals. Dr. Peter Wingate, on my far left, is the Deputy Director of the Colorado Division of Labor, where he administers and enforces Colorado workplace laws, including wage and hour, immigration, youth, and union laws. He has extensive experience in providing expert witness services and support and employment law, and is the author of the Division of Labor's Guide to Labor and Employment Law Topics. Peter is recognized nationally for his publications in the legal, scientific, and human resource domains, and has participated as a featured speaker in over 100 different presentations. A number of them have been to the members of the Colorado Restaurant Association. He received his doctorate in industrial and organizational psychology from Colorado State University, holds a master's degree in psychology from San Diego State University, and obtained his bachelor's degree in economics and psychology from Colby College in Maine. Todd Fredrickson, on my immediate left, is the managing partner of the Denver office of Fisher & Phillips Attorneys at Law. His practice is wage and hour, arbitration, collective bargaining, union campaigns and elections, employment policies and procedures, employment discrimination, and related litigation and labor and employment litigation. His practice involves representing employers, that is key, in various matters under employment law. His bachelor's and Juris Doctorate are both from the University of Colorado. On a personal note, I think that it is important when selecting an attorney that they specialize in the same area as your problem exists, and that they are on the same side as you are. My experience is that people have a difficulty serving more than one master today, and there's another today and another tomorrow, and moving well from one specialization to another. I had a client, and they were using a lawyer whose specialization was real estate for their human resource, and they got beat up badly in court. We will start today's festivities with Peter and follow that with Todd's presentation. I would ask that you hold the questions, as Sarah indicated, until the end of the presentations. If you could write and make notes on them, I would appreciate that. We will have a lot of time at the end to handle those questions. Without further ado, Todd?
Peter.
Or Peter.
Thank you, Andy, and thank you very much to our host, the Restaurant Association. It's a pleasure and honor to be here, and it's always a wonderful opportunity for the Colorado Division of Labor to share our state laws and updates with such a large and noteworthy force in the state. And in thinking about this presentation, I'm really going to touch on a lot of broad topics, delve a little bit into each one to put them on your radar, and then so at a later date you can touch base and then seek out legal counsel or come to the division with more questions, because we have so many highlights and new developments. It was hard for me to commit to any one. But as Andy noted, we will talk about the new wage theft law. That's really big on our radar here in Colorado. It just went into effect about a month and a half ago. And then I'll give you an update on some state wage and hour developments, our social media law, which applies most likely to all the members of the association, our credit history law, which also likely applies to all the employers in this room and on the web, and our employment verification law, which was new in 2007, another unique Colorado state workforce law that applies to all employers in this state. So we've got a lot of updates and directions to go in, and I will just jump right in and start off, give you a little bit of information about the Division of Labor. Thanks, Andy, for the kind words about us as compared to the federal government. We do try our best. We try to assist both employers and employees and enforce and implement laws in a fair-handed manner and do our best to do that. And a part of that is education to the public. You'll note that all of you in attendance and on the web should have at least 3 fact sheets. One of them's on our new minimum wage, one's on the employment verification law, another on the Wage Act, and lastly, for the attendees in the room, I gave out a draft of our frequently asked questions, which are not yet available to the public. It's a brand new item in development, but you'll see that on the website in a week or two. Those frequently asked questions are about this new wage theft law, which is going to be a significant learning curve for employers in the state and restaurateurs to come to terms with. So those are some of the materials we have here, and I know the PowerPoint will be available as well. And our division generally is part of the broader Colorado Department of Labor and Employment. The department itself has about 1,200 employees. A lot of those work in the unemployment insurance and workers' comp area. But my specific division focuses on these wage and hour issues that have grown in significant importance in the last 10 years as litigation has exploded and FLSA class and collective actions are emerging across the landscape, and new legal theories are coming about on how to take on employers. We've also got immigration laws, workplace conditions laws, such as that social media law and credit history law I'll talk about. I'm not going to talk about youth employment or labor relations, but note that those are also within our purview at the State Division of Labor. And we've always been historically a fairly small division, and wage and hour was our bread and butter, but in the last few years we've expanded our empire and gotten new new legislation and new funding to go in new directions. And a lot of these laws are groundbreaking and unique across the U.S. An important point to remember is that if you're a multi-state employer, you're likely confronted with a lot of other state laws that diverge from Colorado's. And Colorado's laws are certainly different than federal law in a lot of instances. And when both laws apply, you always have to follow the law that provides the employee with greater benefits.
The employee.
Yes.
That's the key.
Yes, that is the key, Todd. So the law that's more restrictive against the employer that provides the employee with greater benefits, for example, our state overtime law provides 12-hour protections per day, whereas federal law only provides 40-hour per work week protections, is a great example. And I thought we should just jump right into the newest material because it's most interesting and with greatest applicability, this Wage Protection Act that the governor signed in May, legislature passed last year, went into effect January 1, applies to every private sector employer in the state. And this law is really about the process of wage complaints. It doesn't expand really the substantive protections for the workers, but it gives them a really new avenue with a lot greater teeth to file complaints, get penalties, have fines assessed against the employer. It's turned my division more or less into a judicial arm as opposed to in the past we were more of a mediation type agency and it was more of a voluntary process. So there's just a lot new enforcement side, and this is a nationwide trend. You're seeing other states do this as well. The Obama administration has put a lot of teeth into their wage and hour. And a noteworthy aspect of this law is it applies only to wages earned on and after January 1 of this year. So we're going to have a 2 or 3 year transition period wherein wages, complaints will come to our agency that involve wages pre-January 1 and post. We'll apply this process to both, but the fines and penalties will only be on the wages earned after January 1. So over time, this will take over all of our complaints. And so how does it work? We start off here. Here's some of the boundaries. Like in small claims court in Colorado, if we get a wage complaint from a current or former employee, they can come to us, and our process is limited to up to $7,500. So if the employee alleges that they're owed $7,500 for a variety of reasons, and I'll talk a little bit about that more in a second, then they can come to our agency or they can pursue the matter in court. They have their choice. They could go to small claims court or come to the division. My process is not a prerequisite for litigation. Or they could get an attorney and go straight to county court or district court depending on the limits of the suit. So we've got some of these limits. It's only up to $7,500. It's for work performed on and after January 1. There's up to a 3-year statute of limitations on wages owed. So an employee could come within 2 years typically, or 3 years if we determine it was a willful action of the employers to allege unpaid wages. And then one of our compliance officers would investigate, and that's where you as an employer, an attorney, an HR professional would typically be contacted by my division by letter, and that letter would note what the allegation is, who's alleging it. We don't take anonymous complaints because we have to be able to do some fact-finding and adjudicate this. And then we would give you time frames to respond to the division on the complaint. And after that investigation occurs, which involves exchanging information between all the parties, employee, employer, and the division, we would render a determination which includes those wages owed up to $7,500, penalties which would go to the employee, and fines which would come to the division. So if you've been a subject to wage complaints by my division in the past, the fines and penalties are the new part for you. And an eye-opener, and they can be very significant, as we'll talk about. And then at that stage, if either party disagrees with that compliance officer's first-level decision, that's appealable to a hearing officer. We've now created hearing officers in an appeals unit here at the Division of Labor. And then in the event, they would hold a hearing with both parties, go over the evidence, rule based on the law and findings of fact, and then that decision would be available to district court. So this is really a parallel, separate process to the court system. But the thinking by the legislature and the proponents of the bill is that my division has greater expertise in this area. We've got about 10 or 15 investigators who solely do these claims. So instead of the court system, which may not see them as frequently or have as much exposure to the laws and regulations, our division may be better equipped. And it's a free process for the complainants, hopefully speedier than the judicial system, although we will certainly have growing pains in this first year. as we're trying out a lot of new systems and processes and training new employees. So what happens then after that process kicks into gear? Well, we've got these penalties that can be the larger of 125% of the wages owed or 10 days of pay, whichever is greater, and if willful, those penalties can increase by 50%. So, for example, if the employee alleged and it was found they were owed $7,500, the penalties could go up to about $9,600. That's 125% of $7,500. And you increase that by 50%, we're talking $14,000 or $15,000. So a $7,500 wage claim can lead to double that essentially in separate penalties. And then we've got fines that come to the division now, and we've got three broad categories of fines. The first fine being failure to respond to the division. Any failure to any letter or correspondence could be $250 each. That's relatively small. The next two are much more noteworthy. This brand new fine on pay statement violations. If you're not complying with Colorado wage and hour laws on what your pay statement contains, how long you retain it, when you give it to the employee, you could face up to $250 per month per employee, up to $7,500. And then lastly, the biggest fine of all, possibly, is up to $50 a day, which commences from the date the wages were due and payable. So an employee that you didn't pay for, say, for 2 years continually, or just sometime in the past 2 years, conceivably could be $50 a day. We're talking up to, if you go to 3 years, could be up, $50,000 fine, say if it was willful. So I'm not trying to scare you. Hopefully we're gonna devise some matrices and standards and rules in the next year that will be reasonable and take into account employers' defenses and the procedures. I should note one of the most important new parts of the law, which is not on the PowerPoint, is that the law now states the employee can send a written demand at any time to the employer for wages. And when you get that written demand that comes from the employee, not the division, you have 14 days to pay them what's owed. And if you don't, and if it's ultimately found that you did not pay what was owed, that you owed more, then those penalties are really hard to avoid. They typically can't be waived. So you have this narrow window where you're going to have to grapple with going to legal counsel, really delving into payroll. I mean, your accountant may be out of town, it may be a vacation. It's just a new set-in-stone bright line in the law. And this written demand can occur any time from a current employee. That's also a noteworthy change in the law. Under the old law, you had to be separated from employment, and then you had 60 days to send this written demand as an employee to try and get penalties. Now an employee can send it any time. It triggers a 14-day window to respond. So when you get that demand from an employee or you get a notice of complaint from my division, take notice right away, because those time frames are hard to adjust or escape if you don't pay what's owed. And that's the real nutshell of this new process, and that process applies to all the complaints my division receives every year. It applies to these laws, it applies to our state minimum wage, it applies to our wage order, it applies to our state overtime, our meal periods. We get about 30,000, 40,000 phone calls a year, but in terms of these written complaints, 5,000 to 6,000. That's been as high as 7,500 in some years, as low as 4. We're unsure whether this law is going to stimulate a much greater amount of written complaints, or conversely, if lawyers recognize the teeth that the division has, maybe they'll get everything right and preempt complaints. So we're unsure whether it's going to be driven up or down, but we do a lot of these every year, and now it's a true enforcement process as opposed to mediation. In thinking about the state domains, and Todd's going to go into much greater depth on the federal law and a lot of these that I'm going to touch on, but in terms of those 5,000 complaints we get at my division every year, the top areas would be final pay. You've got a certain set time when you fire people, lay them off, or they quit to pay them. Overtime, rest and meal periods. Overtime is the biggest area maybe of litigation because it's so fertile for trial lawyers. Deductions from wages, really complicated. Colorado law is very unique on that. It's different than federal law. I'll talk a little bit more. But we also handle contractually promised pay. That's something the federal government doesn't do. If your employees were promised $20 an hour and you paid them $10, we would investigate that, but the federal government would only be interested in the minimum wage and overtime components. And we've got a unique state law on vacation pay, commissions and bonuses to the extent you provide or operate under those systems. Then we look at your written agreements. Certainly we hope you have written agreements if you're doing those types of things. And off the clock and minimum wage. So these areas really big at the state level and certainly federal level too. And here we are a month and a half into the new year, so I certainly hope you're all abiding by our new minimum wage, which kicked in on January 1. That was due to our new inflation rate of 2.9%. For those of you who haven't been following the trends in Colorado law, since 2006 we've had to adjust our minimum wage annually to inflation pursuant to a constitutional amendment enacted by the voters. And so now we're at $8.23 and $5.21 for tipped employees. And that will change a year from now. We typically get that data in August. So if you ever want to know or have a preview of what it's going to be the coming January, talk to us in August. And we had two sets of rules that came into effect on January 1, too, both to codify this new minimum wage and to implement aspects of that wage theft bill that I just talked to you about. And here's a little history on our minimum wage. You can see we were stuck for a long time at that $5.15 level, along with the federal government way back when. And then starting in 07, when Amendment 42 kicked in, we went to $6.85. That amendment just said it shall be $6.85, shall be $3.02 less. The tip minimum wage is always $3.02 less than the full wage. That's in the Constitution. And then every year it's been adjusted. The most interesting and noteworthy aspect, in 2010, we were the first state agency in the history of this country to lower their state minimum wage pursuant to that deflation of 0.6%. Of the 12 or 15 other states that adjust their minimum wage for inflation every year, we're the only one, to my knowledge, that actually is willing to actually decrease it when it goes down. But of course, doesn't mean you have to lower it for your employees. In terms of morale, it may not be the best idea. And then secondly, in that year, federal minimum wage was $7.25, so you would still have to pay a cent higher under the federal government's wage. So you always have to compare our minimum wage to federal, see whichever's higher, and that's what you have to abide by. Our tip minimum wage is significantly higher than federal tip minimum wage of $2.13 right now. So that's a big difference for those of you in the restaurant industry here in Colorado. And speaking in terms of our wage order, that's our regulation that we promulgated. It's applied for dozens and dozens of years to the food and beverage industry. That's what we're talking about here. So virtually anyone in this room or online should be covered by this wage order. And the wage order is what dictates how you pay overtime to employees, and also meal period and rest period rules. And these haven't changed in a long time in Colorado, but it's noteworthy for me to highlight them. We've got the 40-hour standard for non-exempt employees. Just like the federal government, you have to pay time and a half or work in excess of 40 hours for a work week for those non-exempt employees. Then we have those two unique 12-hour rules that kick in. A handful of states in the country have these types of daily rules, workday or consecutive hour rules for your non-exempt employees when you have to pay time and a half. California may have an 8-hour rule, I believe. Mm-hmm. And
Saturday and Sunday work.
And Saturday and Sunday too. And so that's a good area too, that Todd's noting, that we do not have a reporting time pay or scheduled show-up time pay rule in Colorado. So there's no minimum you have to pay your employees if they show up and you don't have work for them that day. So we don't have that here in Colorado. But we do have the 12-hour OT rule, so certainly be aware of those. And then in order, probably the second most significant thing in the wage order that applies to your industry would be our meal period rules, where these non-exempt employees are entitled to that 30-minute meal period, where if they're completely relieved of duties, free to leave the premises, you don't have to pay them. But if you restrict them to the premises or require them to perform work during that time, then you're going to have to pay them for the time and allow them to consume a meal of their choice on the job. And that's a half-hour period whenever the scheduled work shift exceeds 5 consecutive hours. So meal periods are dangerous if you've got a system that automatically deducts for meal periods from their wages or carves it out, but they actually end up working. So be careful with those automated systems that don't take into account employees who are actually working through meal periods. And then for every 4 hours of work, employees are entitled to a 10-minute rest period. They're not necessarily entitled to leave the premises. We don't have a smoke break rule in Colorado. So they can be restricted to premises, and typically things like just using the restroom or just slow periods of work usually comply with that. So the rest period is a little less significant than the meal period in Colorado in terms of liability issues. And neither of those is present in FLSA as written. And lastly, a danger zone I want to highlight is our deductions in the wage and hour domain. Our Wage Act says that unless these deductions you want to do are specifically enumerated and listed in the Wage Act, you cannot do them. So what are permissible deductions under our wage law? Of course, those that are allowed by state, federal, local law, like taxes, garnishments. Those are usually typically pretty clear cut. But you get into a danger area when you start giving loans, advances, goods or services to your employee. You're going to want to have a written agreement for those, consult with legal advice on how to craft a legally defensible written agreement. But if you're providing your employees with tangible items or money, you want to have that in writing, because virtually any employee, when they're fired and is disgruntled, it's one of the first things they come to us about is they took my pay, they didn't pay me back for X, Y, Z. They will throw everything out there, and deductions are complicated. If you want to deduct for the cost of theft, unfortunately, if that occurs commonly in your industry, then it's got to be filed with law enforcement. You can't just say you have them on video or it's an allegation. There's got to actually be a report filed with law enforcement to deduct from their wages for theft in Colorado. And then you can deduct for things that are typically viewed positively by the employee, such as insurance plans, savings plans, pension. Those are good. And this last one was added about 6-7 years ago to the Wage Act. You may deduct for the amount of money or value of property that an employee failed to return or give you upon termination. So when you gave them a work cell phone and then you fired them, they didn't give the cell phone back, you may be able to deduct for that. But certainly these haven't been tested a lot in case law in Colorado, so we know some employers really want to test limits and others are more conservative. But be careful if you're deducting for money or property and you don't have a written agreement. It is a danger area. You may be entitled to that money owed, it's just you can't deduct it from wages. You have to pursue it separately in a civil action in court under other theories.
Peter, what about vacation advances? So you're advancing somebody vacation that they haven't earned. If you have a written agreement with the employee that at the end of their employment, that can be deducted from their final pay. What's the division's position on that?
Yeah, that's an interesting question. In Colorado, of course, you're not required to provide vacation pay. But once you do provide vacation pay and it's earned in accordance with the terms of an agreement, then it's viewed as wages, and unused vacation that have been earned has to be paid out at separation. And Todd's question is, if you would advance them vacation, so they haven't earned it yet.
Right.
So I would view that the same as any kind of overpayment, perhaps, or prepayment, or loan, or advance. If you had it in writing, I wouldn't view it as earned wages, because they haven't performed the work to earn it. So it's really outside the wage and hour domain. So I wouldn't have a problem if they then left employment and you did not then refund that money or give them money. So I think that wouldn't be earned. And I think we're actually, I'm sorry, we're saving questions for the end, so hopefully we'll have ample time for that. And there's many of those. Vacation pay has always been a gray area, and we do anticipate our division in the coming months and certainly year to have some really good bright line positions on these complicated agreements and forfeiture clauses and when you can condition payout of vacation pay. It's been an area I know it's been somewhat unsettled. And I'm going to switch gears now to give you another brief overview of some other areas. Our social media and workplace law, legislators are really interested in technology and want to be in the cutting edge. These laws are also known as Facebook laws. This was just passed and went into effect in 2013. We became about the 10th state in the country to have one of these laws. And what it does is it creates this shield where employers are not allowed to intrude into employees' personal social media accounts. The thinking of the proponents and legislators was that you wouldn't want your employers delving into your private journal. You wouldn't want them really getting into your private life. So let's try and create this wall for their private social media accounts. And what that means, I've really cut this down to a nutshell. The law, of course, is much more complicated, but there's 3 things you may not do now in Colorado with your employees' personal social media accounts or your applicants. I'll use those words interchangeably. First of all, this is typically an application phase, you can't ask for their passwords or usernames to their account. You can't delve into their private Facebook site, their private feed, what have you. So you can't ask for their passwords and usernames. You may not mandate adding the employer to their contacts associated with social media accounts. This is one where we've seen employers where they may be unintentionally violating this in the state, and certainly as a new law, a lot of employers may be violating this law, where they've tried to, say, increase their social media presence and try and get all the employees to add everyone and share links and friends and highlights. And just be aware, it could be a dangerous zone if you try and mandate or suggest or require that employees add you to their contacts on their accounts. And lastly, the number one issue we've seen in complaints and actual fines has been where employers tell their employees to change the privacy settings on their accounts in either direction. When the law passed, I thought they were going to focus on employers who wanted to see what was on your site to determine whether they should hire you or discipline or fire you. But actually, we're seeing more complaints where employers are telling employees to make their sites private. We don't want our clients seeing you putting all this crazy stuff on your website. We don't want them to know about it. Make your settings private on your personal account. You can't do that either. So either of those is now prohibited under state law in Colorado. There's also a federal law that gets into this domain that talks more about the content of what's on their site. But our state law really deals to access. It wants to keep employers away from personal social media accounts. And with this new law, complaints are taken by my division. We have fact sheets. We have online complaint forms. The law solely mentions my division as recourse. There's no mention of private litigation. And then there's fines up to $1,000 first offense, $5,000 second and subsequent offenses. Fines go to the general fund, not the complainant, so complainants don't have a massive reason to pursue it unless they're really, really angry with the employer. And most of our complaints have resolved around employers attempting to have employees change their privacy settings on their accounts. So be aware of this one. And I imagine it's going to get more and more press as word of this law gets out and we have some bigger complaints. But and the fact is you have a lot of employees. One policy or email from you to those employees may actually create 100 violations. So be careful on that one. Second law, similar in newness and also applicability in the state. It's our credit history law. For those of you who obtain credit histories to make employment decisions, this new state law really curtails your ability to do that. It applies to the vast majority of employers in the state. And the bottom line is you can't use, obtain, or look at credit history, typically credit reports for employees or applicants, unless that meets the law's standard of that information being substantially related to the job. And to be substantially related, it usually means the person you want the report for is either an executive, a director, an officer, someone high up in the organization. You may not get credit reports for your frontline typical non-exempt employees, with the exception being banks and financial institutions are exempt from the law. And this is another trend. Legislators and others are thinking that credit information is rife with mistakes, that employees oftentimes aren't responsible for the mistakes in their credit reports, like medical problems and bankruptcies due to that. So there's not a lot of good evidence necessarily that it correlates well with job performance. So let's keep employers' hands off of it. Definitely consult with an attorney if you're realizing right now you've been doing this in the last year or two, or feel free to talk to me. You know, we're not going to instigate any actions based upon your talking to me today. So feel free to talk to us. But penalties here go up to $2,500 per incident, may be awarded to the prevailing party. So the employee or applicant could get that money, or conversely, if the employer wins, the employer could potentially get awarded the penalty, which is really unique to employment law. So we'll see if that happens.
Yeah, good luck on that.
Yeah, good luck on that one. But I wanted to note the uniqueness of the law because it usually is very one-sided, as you all know. Few complaints received to date, but when we receive them, it is a worry because usually we hear about employers that use a third-party screener. We had 300 applicants, and they all looked at their credit report and used these various metrics and whittled that down to 50. That could have been 250 violations right there, potentially, even though you're only selecting for one or two jobs. So it's unique, but we would only take a complaint on a per individual or applicant basis. We're not going to create class or collective actions of the division in a proactive manner. At least that's not our current thinking. So it would have to come to us on our form, and we would solely look into that one individual, how they were affected by the transgression. Same thing with social media. And then lastly, this one has been in effect a little longer, our employment verification law, but it's very much noteworthy because of the amount of audits we're doing and fines we're levying. This law applies to all public and private sector employers in Colorado, and it applies to all your new hires hired on or after January 1 of 2007. And if they're still in your employment, that's when you have to retain the information up to the date they're fired, they quit, you can shred everything and not worry about them. Different than I-9 retention, no. And this is separate from the federal I-9 process. It's a state law. It is built upon the I-9, but it's one of these real unique ones. No other state in the country has a law like this. It was passed in our 06 special session on immigration. You may remember that when the legislature extended the session to add just a focus on immigration. And so within 20 days of hiring these new hires post-January 1, you have to complete an affirmation form, and you have to copy those identity and employment authorization documents they presented for use with the I-9. Those are the two things you have to do for every new hire in Colorado. Keep them in your files, those copies, and then you produce them to us upon an audit. We've got a mandatory new form that's been in effect since September of 14, so make sure you're using the new current form. And here's some summaries on our statistics. We've done over 7,500 audits. We initiate about 30 a week. That's why whenever I give presentations to large groups or associations, invariably a number of people there have been audited. And you'll get a letter in the mail, your HR will get a letter notifying you of the audit and the fact that we want those 2 items for every new hire that's still in your employ. The vast majority of our audits are random. We use statistical algorithms. We audit state, local, county government, since this applies to both levels. Everyone has an equal chance of being audited by a random audit, but we do take complaints too, complaint forms on our site. We do re-audits if employers fail to comply in the first audit. And a couple things about our standards there. We find over $350,000 total. That's about 200 separate employers. Really just knowing about our law and thinking about our law and hopefully being somewhat concerned about it is a great reminder to review your I-9 process. Focus on that. You face even worse liability and criminal actions too under I-9 law. But to get fined under our law, it's a little harder than federal law. The only way you're going to get fined is either if you don't respond to our audit, if you fail to provide us with information or provide false and fraudulent information, or if you have repeated noncompliance on re-audits or backdate. In other words, if this is the first time you've heard about this law today and you're saying, well, my company's never done this, we don't have these, we're in a world of hurt. It's not necessarily the case, because on a first audit we would have to prove reckless disregard, that you knew about the law and you failed to do it willfully. So usually on a first audit, if you're honest with us, you say, look, I don't have these materials, we'll get it together. We're not going to fine you on a first audit, but we will re-audit you a year or 2 later, and then you'll be liable for a fine. Don't go online now if you don't have these materials and try and create them, try and backdate them. That's a very bad idea and is a guaranteed fine. So this is a new one. I'm frankly surprised it's still around. It hasn't been challenged under preemption grounds. You know, a lot of states were facing scrutiny legally on their laws. And so our law has been in effect now 7, 8 years. It's going strong. So be careful about that employment verification law.
Just make sure that if you haven't been doing it, and you go online and you download the new form, you just do it for new hires going forward. And you can demonstrate that. And Peter and his team will take that into account when you're responding to the notice of audit form, when you say, look, we weren't aware of it. I attended Peter's seminar at the Colorado Restaurant Association. We started doing it as of that date, and you'll see that we have the forms on file from that point going forward. And if you don't have a prior violation, Peter and his team generally will take it easy on you.
Well put. That's the perfect way to put it, because unlike the federal I-9, where you can go back and correct and try and do a form for pre-existing employees that you may have made a mistake on, our law, our view is within 20 days of hire, if you didn't do those 2 things, you can never do them, and it's more dangerous to try and go and recreate it or do it right now, because that leads a lot of employers to backdating. So don't do it if you haven't been doing it with any previous employees. Only do it today, starting forward with new hires. You'll be fine. And some new legislation on the horizon right now. Some of this has actually been proposed. Some of it may be proposed in Colorado, and some of it's just possible. But we've got now the same kind of motivation in thinking about banning use of criminal history to varying degrees by employers. varying situations and exemptions. That's called ban the box. That may emerge in Colorado, just like it did with credit history. The prohibition of discrimination against the unemployed, that's been around, attempted a few times in our legislature, where employers are prohibited from using those advertisements that say unemployed need not apply, don't apply. Those are very offensive to many. Mandatory paid sick leave, which would be a massive change, cost a lot of money, be complicated to implement. I would imagine seeing that being proposed in the coming weeks for Colorado. One or two other states have such a system, but it would require hundreds of employees at the state level to implement, and obviously a lot of new burdens and obligations for employers. There's some proposals to change it to independent contractor laws. That's a new danger area, so be careful anytime you're classifying anyone as independent contractors. There's been push and shove in the Colorado Pay Equity Commission. I'm not sure where that ultimately ends up, which has been around for a number of years and issued some reports. There's some attempts to amend our civil rights laws to repeal some of the changes that happened last year and previous years that expanded liability. And then federal changes to FLSA, President Obama is suggesting that we raise the dollar limit whereby individuals are exempt or non-exempt, and that could be very significant for who you can call a manager and just pay them a salary, not have to pay overtime. So those are just some teasers for the future. And we also oversee a variety of other topics. So if you ever need help from the division, we've got another employment verification law. Workplace accommodations for nursing mothers is a new focus since 2008 at both the state and federal level. So make sure you accommodate those that have a new child within the first 2 years post-birth. And then union labor youth. We've got a lot of online materials to check out. And I think my time runneth over. So with that, I'll turn it over to Todd.
Thanks, Peter. This is really important stuff, and I'm glad that this is now the third time that we've talked to CRA members about wage and hour issues, because we want you to get it right. We want you to get it right for a couple of reasons. One, if you get audited, we want to make sure that you have your ducks in a row. And also, if you get a demand letter from plaintiff's counsel, or even worse, a lawsuit, we want to make sure that you've gotten it right. So I appreciate CRA and Andy's lighting a fire under Peter and yours truly to make sure that we're regularly talking about these issues. And some of you who have attended these presentations in the past will know that we're going to talk about some of the same issues that we've talked about in the past. But we're also going to focus a little more today on federal audits, because I want you to be prepared for that. Of late, they have been stepping those audits up in the restaurant industry as well as the construction industry. That initiative has been on the books since 2008, but for some reason in the last year, it seems like more and more of our restaurant clients are being targeted by the feds. Peter alluded to this before. You'll see that there's quite a bit of overlap in the materials in these little colorful charts between what's covered by federal law and what's covered by state law. And the big difference is that with Colorado wage and hour law, the payment of earned wages is the big trigger or the big ticket for lawsuits, because if you're not paying earned but unpaid wages, commissions, bonuses, vacation pay, you can be on the hook, as Peter described it, for pretty hefty penalties. And then on top of that, these cases become very top-heavy with attorney's fees. So you're fighting over, even in the smaller amounts, under $7,500 bucks, but let's say you're fighting over 10 grand. You get an attorney who's spending, $60,000, $70,000, $80,000 to pursue that, and if they win, judges in Colorado are awarding those attorney's fees even when they're only recovering, $10,000 in earned but unpaid bonuses, vacation pay, etc. So you can see that the stakes are high. That's why we want to make sure that you understand the basics of both federal and state wage and hour law. The good news is that if you're complying with what Peter has told you about this morning, chances are pretty good that you're also complying with federal law, but there are some nuances that we want to talk about. Now, with audits in particular, the question I often get is, well, how do you know when you're getting audited? And the Federal Department of Labor is kind enough to send you a notice of audit letter introducing themselves, letting you know that they're going to be auditing you. That audit can be the product of a complaint, or it could be a random audit. They won't tell you whether it's a complaint or a random audit, and there are equal numbers of both. But usually, in most industries, other than the restaurant industry and the construction industry, it's because of a complaint. In 2008, when Chuck Fraser, who's the head of the USDOL regional office here in Denver, decided that he wanted to expand their enforcement effort. They went from more of a compliance-oriented approach, which is what Andy was talking about a little while ago, where they were partnering with business more, to more of an enforcement effort. And they knew that there were a lot of violations in this industry as well as in construction. And so they made it a key initiative of the Denver field office to start focusing on restaurants and construction employers. That's been going on since January of 2008. And so if you're getting audited, pretty good chance that it's a random audit, that there isn't somebody who's blown the whistle on you with the Federal Department of Labor. But it doesn't matter because the investigation is exactly the same. They will, in their notice of audit letter, give you a request for information. They'll ask you for all kinds of records that they want to come in and view. And my advice to you would be you cooperate with that because they have subpoena power. If you say, heck no, they're going to get it anyway, and so why not sort of put your best foot forward and start to prepare the documentation that you're going to supply. And they'll want to see time records, and they'll look at, if you have 50 or more employees, they'll want to see your FMLA policy and related records. If you're under 50, they won't bother themselves with that. They may just ask you, how many employees do you have? And when they see that you're not an employer that's covered by the Family and Medical Leave Act, then they'll just focus on the wage and hour issues. They may or may not ask to speak with witnesses. And so you need to know that there's a difference between supervisors and non-supervisors. The Department of Labor does not have the right to speak to supervisory witnesses outside your presence or the presence of counsel. You can insist that your lawyer be present, or if you're the owner, if you decide that you want to handle the audit on your own, you can be present for those interviews. With non-supervisory employees, the agency is entitled to speak to them outside your presence because they're concerned about employees being coerced into testifying a certain way when you're present because they don't want to piss off the owner or their manager. And so the Department of Labor will be very aggressive about making sure that it's the investigator and that employee speaking person to person. But that's part of the overall investigation into whether you have violated minimum wage or overtime laws or even the record-keeping requirements of the Fair Labor Standards Act, the federal law that governs here. And it is different than the state law in the sense that it only requires the payment of overtime when employees work over 40 hours as opposed to the daily overtime requirement that the state has under minimum wage order 31. They'll also investigate you for minimum wage compliance, and they know that the state's minimum wage is higher. Their jurisdiction really is to make sure that you're paying federal minimum wage, but there's some language under the FLSA, just like there is under our wage order, saying that whatever provides the greater benefit, you need to pay. So if you're not paying the state minimum wage, that's going to raise their eyebrows. They might call their friends over at the State Department of Labor to alert them to the fact that there's been a mistake made and the employer's only been paying federal minimum wage. The other question I get is, well, when can we challenge the determinations that are being made? And my answer to that is sooner rather than later. Oftentimes we get the call after something called the WH-56 has been issued. That's the determination letter that has employee names with the amounts that they believe are owed to those employees. It's not too late if they've sent you the WH-56s to sign. Once you sign them, they are very difficult to unwind. And the Department of Labor can initiate an enforcement action to try to enforce those back pay determinations that they've come up with. So we want to get in, or if you know how to handle these audits, we want to make sure that you're challenging the determinations as they're being made. And it is a lot of sort of adjusting on the fly. For example, you'll get an auditor who will say, I think you've got a real problem here because you've classified this supervisor as exempt and you've only been paying them a salary, but I don't think they're a supervisor. You should have been paying them overtime. And you get into a little bit of a, for lack of a better way of putting it, a kind of a pissing contest about whether they're exempt or non-exempt. But you want to have that, you want to have the ability to challenge that right then and there. And if you have evidence that they are, for example, regularly directing the work of 2 or more full-time employees. That's oftentimes where you get into a dispute when you're talking about managers or supervisors. Do they actually direct the work of 2 or more full-time employees or their equivalents? So it could be 4 20-hour-a-week part-timers, and those could be the equivalent of 2 full-timers. And you're pulling together, you're marshaling this evidence that they're actually supervising those employees to try to convince the auditor that that person truly was classified properly as exempt. You want to do that as you're getting that feedback from the auditor, and oftentimes you'll get that during the initial intake interview. Sometimes you'll get it in email or during a conference call with the auditor where they say, I think you're really clean on the minimum wage issues and the tip credit, and your tip pool looks clean, but I'm really concerned about these exemption issues. Or they'll say, I think you're clean on these other issues, but I have to say I've got a problem with your tip pool because it looks like you are allowing supervisors to participate in it, and supervisors shouldn't be participating in a tip pool. You can say, well, that person isn't really a supervisor. Well, I was talking to your employees, and your employees refer to so-and-so as their boss. Well, I don't know why they're calling that person boss. At most, they're a lead, but they don't have the power to hire and fire. They don't supervise. They don't schedule. They don't evaluate. They don't do any of the things that would make them a supervisor. And so you get into a polite, cooperative argument with the Department of Labor as to why they're wrong about whether that person can participate in the tip pool. So, if you have any questions, you want to be challenging that before you get the WH-56s, okay? And if you need counsel, we can certainly help you with that. And then when you get those statements, you want to look them over and make sure that they're in line with what you and the investigator have agreed to. Sometimes the investigator will go back to their supervisor, and the supervisor will find an incorrect calculation or may take issue with one of the recommendations, and so those numbers don't quite match up with what you thought you were getting. That's the time to challenge that before you assign it. And then the other thing is there room for negotiation? And the answer is a little. They're there to get back pay. If they believe back pay is owed to your employees because you improperly used the tip credit, or you improperly used a tip pool, or you didn't properly pay overtime, or you were not paying employees for working during duty-free lunch breaks. That's one area where the FLSA will get involved with lunch breaks, is that if an employee works 1 minute during their 30-hour duty-free lunch break, the Federal Department of Labor is going to expect you to pay for it. And employees tell the auditors all the time, oh yeah, I always work through my lunches. And so you get, an initial back pay determination for every day over the last 2 years that employee worked, unwinding their duty-free meal break, and that's another one of those areas where you say, well, wait, not so fast. That person was taking their full break, and if they're saying that that's not the case, it isn't true, and here's my proof of that, if you have proof of that. If you're using a time clock, a computer timekeeping system, oftentimes it's easy to be able to prove that, because that, in connection with a policy that says, look, when you're on your duty-free lunch break, those words duty-free mean something. We don't want you working. We want you cooling your heels, using the full half hour, and if you don't use the full half hour, that's a performance issue, and you can be disciplined for that up to and including termination of your employment. That's how you deal with that issue. But if the employee legitimately took a phone call during their lunch break, even if that phone call lasted all of about half a minute, it's no longer a duty-free lunch break, and you got to compensate them for that. So be very careful. It's one of those blind spots that especially restaurant employers get into. So going back from that tangent back to the slides, the room for negotiation. Oftentimes there is room to negotiate the liability amount, but it has to be well reasoned. I mean, you have to have a legitimate basis for why you're challenging the liability. Sometimes it's they miscalculate. Sometimes they will have you reconstruct the hours that an employee worked, and they can't read your writing, and so they make a clerical error. Other times it's because there's a genuine dispute as to whether somebody's entitled to overtime or not, whether they're properly classified as exempt, And if you have a good argument, oftentimes the Department of Labor will back off of that position. It seems like of late they've taken many more aggressive positions in these audits, and so you got to challenge them where you have a pretty good inkling that you're right about an exemption issue or an overtime issue or a duty-free lunch break issue, and push back on that politely and cooperatively. Because if you're being a hard ass, pardon my French if that is French, is you're going to just draw their interest more, right? So the appearance of cooperation can be I can't believe I'm saying this in front of Dr. Wingate, but the appearance of cooperation can be a very important thing, okay? You can also negotiate the time for payment. So oftentimes these back pay determinations can be pretty hefty, and you may not have the liquidity to be able to pay that back pay determination right then and there. The USDOL will work with you to a point, but you, again, have to go to them with a reasoned basis for why you need time to pay. But you need to know your rights, and don't get strong-armed. And it is absolutely true that if you are a shrinking violet, our federal Department of Labor will take advantage of that. So either find somebody in your organization who isn't a shrinking violet, who knows something about these issues and can stand up to the federal Department of Labor, or you better make sure that you're using your attorney to help with this, because there is a difference in how our federal Department of Labor deals with you directly than when they're dealing with counsel. They're just much more open to counsel's argument and a position statement about why you properly classified somebody as exempt. That sounds like a plug, and to some degree it is, but I can tell you that the Department of Labor is much more deferential when I'm involved than one of my clients is involved directly. Part of it is because I've been doing it for a while, and so they've seen me before, and they know that I know a little something about wage and hour law. And frankly, I don't care if you use me. If you need counsel, just get somebody who knows something about wage and hour law. Or, call your buddy Andy Devine. And Andy can help you with some of these issues too, or at least steer you in the right direction. I just don't want you to fall prey to what can oftentimes be some strong-arm tactics you don't get from the state, but you do get it from the feds from time to time. All right, so that's the sort of audit process in a nutshell. Some of this will be a refresher for some of you, because I like to talk about sort of the 5 deadly sins that lead to both audits and litigation. And this is the biggest one. This is the one that the plaintiff's bar is paying the most attention to with your organizations, and that's screwing up tip credits and tip pools. So the first thing is that if you don't have your tip credit explained in writing to your employees that preferably they have signed off on, like a tip credit and tip pool memo, and you're taking advantage of the tip credit, you're paying the state tipped employee minimum wage as opposed to full minimum wage, you darn well better have spelled that out to your employees in a way that they've signed off on. You can do it in a tip credit, tip pool memo, or some other acknowledgement where you explain what that tip credit is. By the way, Peter was talking about Colorado Minimum Wage Order 31. The number changes every year because the minimum wage goes up or it's revised and stuff. Well, that's really the only way that it gets revised, right, anymore, it seems like. But the current one is Wage Order 31. That is a great cheat sheet for employers. Just like a couple of fact sheets that we've given you, the Federal Department of Labor fact sheets 2 and 15 spell out a lot of the things that we're talking about today. A lot of my clients post them, sort of a we have nothing to hide, this is what we comply with, and those things are posted. And when they're posted, oftentimes I've had some success in saying, well, the employees were put on notice that we take the tip credit because the federal and state wage and hour posters were posted. Minimum wage order was posted. It provides a lot of detail on tip credits and tip pools. But I never think that that's really enough. I would much prefer to have somebody sign a memo where this sort of stuff is spelled out. You need to let them know what the amount of the tip credit is that's being claimed. These have to be revised from time to time to the extent that the tipped employee minimum wage goes up, and it does in our state. As you could see from that one slide that Peter showed you, it has changed every year. Even the year where it went down, I think the tipped employee minimum wage went down, didn't it? It would naturally, right? Yeah, 302, so naturally it would have gone down. And you got to make sure that you're monitoring your tip credit to ensure that your employees are still making minimum wage. For most of you, if not all of you, it's a non-issue because with tips, it takes your employees well above minimum wage. But you need to build in a check and balance to make sure that you're paying the minimum wage, especially as it goes higher and we become subject to things like, you know, if the feds raise minimum wage at some point. Right now it's just federal contractors that are paying $10 an hour. But there is some movement to try to increase that to the private sector. I mean, good luck with the current Congress in getting that passed, but you just know that that's out there. You want to make sure that you're complying with whatever the applicable minimum wage is, whether it's state or federal. And if you have stores or restaurants in more than one state, know that you always need to be thinking federal law and state law. Am I complying with federal law, and am I complying with state law? If you have operations outside of Colorado, make sure that you're looking to see if a particular state has its own minimum wage order. Employees have to receive at least $30 a month in tips. Usually very easy to satisfy that, but you need to have in place some system to monitor that. The feds have a 20% rule that say that, you know, if your servers, for example, are spending more than 20% or more of their time in prep work or maintenance, you have them out there shoveling the walk after a big snow day, they're spending more than 20% of their time doing that, the feds are going to say that that they ought to be paid the full minimum wage for that. So be very careful about that. Again, usually not an issue, but we've had some of our restaurant clients get in trouble with that. And then also you want to remind employees, preferably in the tip credit and tip pool memo, that tips are the sole property of employees. Then when you get to tip pools, again, advance written notice is the key. Can't stress that enough. Frankly, I feel so strongly about this that if you send me an email to my email address, tfredrickson@laborlawyers.com, it's on the first page of the slides, I will share with you my form tip credit tip memo, and you won't even get an invoice from me for that. I want to make sure that you're using the right tool that's tailored to fit your business so that you don't get Backus and Shanker, any other cheesy plaintiff's lawyer, digging around your business. Only employees who customarily and regularly receive tips can share in tip pools. The yes category is pretty obvious. Servers, counter personnel who serve customers. You want that direct, regular, daily, hourly customer interaction. Bussers and service bartenders also have been found to be people who can share in tip pools. No, owners, managers, any supervisor, janitors, dishwashers, anybody in the back of the house should not be sharing in a tip pool. And then you have sort of the closer cases like hosts. There's an Outback Steakhouse case out of the 6th Circuit, I believe, that says that hosts who had regular interaction with customers could participate in a tip pool. Barbacks, that's a little bit closer case because they don't have that direct customer interaction oftentimes. So, you know, you can skin this in one of two ways. Either take them out of the tip pool or make sure they're not participating in the tip pool, or change their jobs so that they're having that direct customer interaction. They're working just like the service bartender. Expo or expediters, that's a real close case. There's case law saying they can't share in tip pools, and there's some case law saying they can to the extent they're more like a server helper. And they're doing more of the work at the table with your guests. And then my favorite category, employees who act like they're supervisors. And if you allow that to go on and an employee gets interviewed, they'll refer to that person as their supervisor. And that's just going to draw the attention of the Department of Labor or a good plaintiff's lawyer. So, and I've had that case come up where the allegation was that this particular person who shared in the tip pool, who was a sushi chef, was a supervisor. And the client can say to me, that person is not a supervisor. But the employees were telling their lawyer that he was directing their work and scheduling their work. And so we got into a big fight over that. And it dragged out the lawsuit. There's an easy way to deal with that. Draw a distinct line between those people who are supervisors and those who aren't. And the reason I put here, if you get it wrong, is that if you get tip credits and tip pools wrong, the liability can be really significant.
I know you know my question.
Yeah, hold that thought.
Which was kind of the perception is reality, that
Yeah, so the question from the back was, the illegal question from the back was perception versus reality, and perception sometimes can be as strong as reality, and if somebody believes that a person was supervising them, there may be some reality to it. Maybe that person was directing their work, and then you've now allowed somebody who ostensibly is a supervisor to participate in a tip pool, and now your whole tip pool is subject to challenge. So anyway, go back to the fact sheet. I forgot to add fact sheet number 2, and also recognize that there's quite a bit of overlap with minimum wage order 31. I should have changed that too. This obviously was my presentation from 2014, not updated for 2015. It's minimum wage order 31. We've talked a little bit about this issue, misclassifying employees as exempt. You know, this is one of those things that gets challenged oftentimes in both single plaintiff and collective action, which is multiple plaintiff lawsuits. It is one of the most common claims that you see in litigation where somebody is classified as an exempt manager or supervisor. That's the one that comes up in your industry the most. And it turns out that they only had one employee who reported to them. Or you have assistant managers. This is another area where restaurants get into trouble. They treat assistant managers as exempt, and they're not really directing the work of 2 or more FTEs. It's the general manager or the manager. And the assistant manager is doing a lot of non-managerial tasks. In fact, they're spending more than 50% of their time helping servers and hosting and doing the things that non-managers do. And the feds take the position that that person is non-exempt. If you've treated them as exempt, they go back and try to reconstruct the weeks in which they worked over 40 hours, and will send you a WH-56 with a back pay determination for that employee. Now, this may be one that you want to go to the mat over, but I can tell you that if you use assistant managers, you've got to be really careful about classifying them as exempt. And title and salary alone are insufficient. I get this all the time. Somebody will say, I'm being investigated, and the auditor says that my exempt employee isn't exempt. I said, well, what exemption did they fit under? And they said, well, they're salaried. I said, yeah, I get that. But what exemption did they fit under? Well, they're salaried. Being salaried isn't enough. It's salary plus. That's how you have to think about this. Salary plus. $455 a week, which equates to about 23 grand a year. If the movement that Peter talks about gets wings, that will likely double. That's what they're trying to do, is to double that amount from 455 to whatever 2 times that is. I'm not going to try to do the math. But right now it's 455 a week. So 23 grand, it would move to roughly about 46 grand if it changed and the current administration had its way. So you got to pay the salary, plus they have to fit into one of the exemptions, and the white collar exemptions are the ones that are most often applied. Executive exemption applies to managers or supervisors. It sounds very lofty, but all they're talking about is managers or supervisors. Folks who have the power to hire and fire or meaningful input into that process, who regularly direct the work of 2 or more full-time employees or their equivalents. Professionals. So, for example, I'm exempt because I have an advanced degree, and actually, some might dispute this, use that advanced degree in my daily practice. I'm also a manager, right? I manage other attorneys in my office, so I fit under the executive exemption. Then you have other exemptions like the administrative exemption. This one gets abused a lot and gets unwound by the Department of Labor a lot. HR folks, sometimes HR managers are classified as exempt when in fact they're not. Bookkeepers, that's another one. If you have somebody who you slap the label Director of Finance on, and they're really just a bookkeeper, the Department of Labor might try to unwind that. And you have both a duties test and a salary basis test. Some of the learned professional exemption, for teachers, for example, doesn't have a salary basis test to it like the executive exemption has. There are about 23, 24 other listed exemptions. It's one of the areas where there's some slight differences between what the state does and the feds do, but they're pretty parallel. There's some slight changes.
If you look at our wage order, you'll notice that it's a lot shorter than federal regulations and law. So typically when our law is silent or it looks like it's trying to emulate or mirror what's in federal law, that's our goal. So you may have one sentence talking about these white-collar exemptions in our law where we believe that it is intended to be the same as federal law. So most of the time, very similar on a lot of tip provisions too.
Record-keeping mistakes also can expose you to an audit or to litigation. You want to make sure that you have accurate records of hours worked. That's why I love time clocks and computer systems that are properly used. Now, that doesn't mean that employees won't forget to clock in and out at times, and the answer is not to dock or deduct pay or to refuse to pay them. It's a performance issue, and just like other things that you have to do as part of your job, you got to make sure that you're properly clocking in and out, and if you're not, you're subject to corrective action, and that's how you deal with an employee who doesn't comply with your timekeeping requirements. And when you do have mistakes, I like to see something signed by the employee, either a time card that's initialed by the employee or an acknowledgement from the employee that says that the records now accurately reflect their punching in and punching out for that week. Be highly suspicious of supervisors who are editing time records. Easy way to get yourself in trouble. It's highly suspicious activity to both the feds and the state. I think even the state would look at that with some suspicion. If your supervisors are editing time, oftentimes supervisors edit time because they want to do what? Avoid what? Overtime, right? Because you've been cracking down on the supervisors saying, look, our overtime is way out of whack, knock it off, get your employees to knock it off. And so they are unwinding actual hours worked. That's a big no-no. Frankly, that can expose owners and supervisors alike to individual liability under the Fair Labor Standards Act. And the documentation I want to see is some sort of acknowledgement signed by the employee indicating that the time records accurately reflect the hours worked for that week and the punching in and punching out. We talked about the duty-free lunch breaks. Just want to make sure that you're properly policing those, making sure that employees truly are cooling their heels for a full half hour if they're taking breaks. And if they can't because it's impractical to do so, remember what Peter said about a meal of their choice. And if you're one of those employers that has lobster on the menu, think about what you would rather have employees do, take their breaks or get the $35.95 Maine lobster tail. I might try to work through my lunch break so that I can get the lobster tail. Miscalculating regular rate and overtime, you want to make sure that you're including everything that should go into the regular rate. That's all compensation that's earned during that week. So if you have any sort of non-discretionary bonuses or other pay amounts that you're paying employees, maybe there's some sort of employee incentive program that you've created that you thought was a great idea, like gift cards or things like that, that could require you to factor that into the regular rate. If it's unplanned gifts, just somebody's been doing a good job and you give them a $25 Starbucks card, note the word unplanned. You don't have to include that in the regular rate. If it's a discretionary bonus, somebody's done a really good job and complete surprise to them, you decide to give them a little extra around the holidays, you don't have to include that in the regular rate. But if you do pay those bonuses, just know that you sometimes have to go back and recalculate how that bonus should have been included in prior pay periods. If it was earned, if that bonus was, for example, an annual bonus, you may have to go and calculate that over the year or over particular quarters within the year. It's a real disincentive to paying any sort of bonus to your employees that the feds have created. And then sin number 5, off-the-clock work. You want to make sure that folks aren't working off the clock, that your supervisors aren't asking them to work off the clock. This is a great training point for your supervisors to make sure that when we say you got to record all hours worked, that comes from you as the owner or the person who's running the organization all the way down through your supervisors. You want to make sure that employees aren't performing other types of off-the-clock work, whether it's this pre-shift or post-shift stuff. Training can get you into trouble. A lot of employers think that you don't have to pay for training, but if it's related to the employee's job or involuntary, you got to pay for it. You got to pay at least minimum wage. So be very careful about that. Obviously, paying under the table is a big no-no. It is amazing to me the number of companies that still do that and restaurants that still do that. Off-clock work can get you into minimum wage and overtime trouble. That's why it's the fifth of the deadly sins. And, of course, we're trying to avoid exposure here, right? We want to make sure that you're not getting sued under the Fair Labor Standards Act for back pay. When employees sue, they can get an equal amount in liquidated damages. So if your back pay amount is $25 grand, the employees can get another $25 grand in liquidated damages. And then, obviously, you have this attorney's fee issue that I talked about. That's why so many lawyers, even personal injury lawyers like Backus and Schenker, whose passion is justice, I just can't help myself, is dabbling in this area. So anyway, and you know, you have the statute, you have 2 to 3 year statute, 3 years if it's a willful violation. If you've been caught before and you do it again, it will be a 3-year statute that you will be staring down the barrel of. So be very careful there. Know that this is a strict liability statute. That means even technical violations. No matter whether you intended to violate the law or not, technical violations will get you into the soup and you'll be liable for back pay and liquidated damages. And right now, collective actions and class actions are all the rage, where employees are banding together, like this Chipotle case that Andy talked about, and going after their employers for these back pay amounts. And the difficulty here is, unlike an employment discrimination case where you can wind it up and have a confidentiality provision where nobody can talk about the settlement, you can't get confidentiality in these cases. They can talk about it. You may settle with 10 employees and then 5 more employees come knocking at your door saying, hey, I heard that you paid these other 10 employees, and if you owe them, you owe me. And so it's very difficult to wind up and conclude these matters in just one settlement. There are ways to do it that we will talk about outside the presence of Dr. Wingate, but you got to be really careful about how you do it. And I'm not talking about doing something illegal. I just think there are some tricks of the trade that you can do to get these cases wound up, and more importantly, to get a judge to sign off on them. So do your own internal audits. I mean, if you're doing these things, you're not going to need Fredrickson or any other defense side lawyer. You're not going to find yourself in the soup. If you're doing regular internal audits to make sure that you're doing the things that Peter and I have talked about today. If you've made mistakes, correct them. There are different ways to correct mistakes. There's the make employees whole approach, which is if you've been doing something wrong, going back a couple of years if the liability isn't great, and writing them some checks and cleaning that liability off the books. A lot of my clients like that approach because it gives them peace of mind. Others just fix things going forward, and then they hold their breath for 2 years, right, until the statute of limitations expires. You can do that, but it doesn't give you the same sort of peace of mind. Make sure that you're implementing appropriate policies, from accurate record keeping to prohibiting off-the-clock work. If you find that supervisors are doing inappropriate things, discipline and discharge them. You don't need a supervisor who's exposing you to that kind of liability. And make sure that you have a policy that requires employees to report all time worked, period. No exceptions, no ifs, ands, or buts. And then training of your supervisors along the lines of what we've done today. Even taking these slides and using it to create your own training, I think, is a very good idea. So we said we would leave some time for your questions, and I know that you had a question. You wrote one down because I made you write it down as you were going to raise your hand. So let's talk about what questions you have, because we just went through a lot of stuff.
Okay, I have a couple questions. In paying for training, I was always under the impression that it's voluntary versus involuntary.
Right, that's important.
So
But that's not it. There's a 3-part test, and the 2 parts that come up all the time are whether it's voluntary versus involuntary. And the second one that comes up is it related to the job? So it doesn't matter whether it's voluntary or involuntary. If it's related to their job functions, if you're training on customer service, for example, even though that applies to everybody generally, you got to pay for that. Okay?
And then I was...
So that question, which I should have repeated before I answered it, was, is it just enough to be voluntary or involuntary when it comes to training? And you heard my answer. So you got to ask yourself, is it truly voluntary? And oftentimes it's, well, this is voluntary, but if you don't attend, you do it at your own peril or something like that.
For example, the wine training, it behooves them to
Right.
Do I require it? No.
Yeah, but it's related to their job. So the example given by the person who's asking the question is wine training, W-I-N-E, not W-H-I-N-E, training. And because it's related to part of your sales and the overall experience at your restaurant, it's related to the job, you got to pay for it.
Think about, when I think about this, I think about when I was in the service. And every once in a while, the lieutenant would come down and say, this is all voluntary. BS.
Right.
And so if you want to have your people trained in wine, yes, that is going to really add to their tips if they are very good at it. Doesn't matter.
Right. If you do the training, at your place of business, it's going to be very difficult to argue either that it's voluntary or unrelated to the job. Now, if you have managers, for example, that because of their own personal edification decide that they want to go off and become, or somebody wants to become a manager in your organization, I think it's a closer case if they want to go to some off-site training facility and pay for their own training because they want some upward mobility in your organization and others. If they're doing that of their own volition, you would have to compensate for that in most cases. Now, if you're directing them to go get management training because they're a manager or assistant manager, or you want them to have that upward mobility, that'd be a situation where you have to pay for the time spent training. At least minimum wage. Doesn't mean that you have to pay the full amount. You just got to pay at least minimum wage, and remember that your state minimum wage is quite a bit higher than your federal minimum wage.
Rob?
Did you have more? Because I got like 2 or 3, but one of them, I guess, would respond to that. If you're having somebody come in and for a half an hour, an hour worth of training, do you have to pay them the full minimum wage, the tips credit minimum wage, saying that they get more than minimum wage over the course of that week or that time frame?
Yeah. Well, I'm interested in your take on this, but under federal law, remember that 20% figure? As long as you're tracking below the 20%, the feds would take the position that so long as with tips included, they're making at least minimum wage.
So if you're doing it as a pre-shift and they're clocked in, and you're doing a half-hour wine training before their shift, but they are clocked in at the tip credit wage, that'll be fine.
I think you'd be fine as long as you're not violating the 20% rule. Any departure from that on the state
No,
side?
I agree with you. And our regulations and laws do not specifically address that scenario, so we would typically defer to what the feds say. And I think it's even more powerful in your example there, too. If it occurred during the same day as the tips work, then you're even better positioned than if it was, like a whole work week kind of thing.
So with a couple questions kind of for you, I'll go through 2 quick ones. As far as the affirmation, the copies of the IDs, and what is the use of having those separate than what their employee file is on a regular basis? And then secondary part of that question, why has the Department of Labor then kind of gone from the mediation to more of the, as you said, more of the fine gathering judicial part of it, and the fines have gotten a lot harsher over the last couple of years. What's the purpose of that to help business, if there is any?
Sure. So the first question involved record keeping under the employment verification law, and the question was about retention and location of where you stored affirmation forms and the copies of the identity and employment eligibility documents. And this brings up the issue that, you've got these state law requirements that are unique from federal requirements. And what we've seen a lot during our audits is that you'll have an employer who may be audited by the state, we do a lot of audits, and also be audited by the federal government. And you want to have these materials perhaps distinct, so if you're audited by one and not the other, you don't give away the whole farm to one agency when they're not entitled to it. So, for example, my state agency doesn't want to see I-9s. We can't see I-9s. We don't want to see federal materials. So keeping that distinct for my agency for those purposes can be useful. There's no mandate on how and where you retain the materials, frankly. It's just being able to produce them to my agency.
So when you said there's no mandate, you don't have to keep a separate log?
What you have to do is you have to keep for every new hire who's still employed by your company, who's hired on or after January 107, those copies and give them to us. when we do an audit.
As opposed to just saying, here are our files, you guys do the audit. You're putting that weight onus on us.
Well, you have to create and use the information form on our website,
Yeah.
and you have to copy those documents within 20 days of hire when the employee presents them for use with the I-9 process. So
Yeah.
they have to be copied and exist within 20 days of hire, and they have to just be produced to us upon.
I think the separation protects you. In other words, if you've got all of your information about an employee
Yeah.
in one file, and you present that file, you're allowing a fishing expedition to go on relative to minimum wage, on and on and on. And so if all they want is this, that's all you want to give them.
Right.
So the only thing the state will ever ask for is the affirmation and the photo ID.
Exactly. So when we do those employment verification law audits, they are totally distinct from wage and hour and any other law that I stated, and they're all independent actually. So we would just look for those two things, a list of all your employees who were hired after January 1 of 2007, who are still employed, and those two things, nothing else.
Well, and
So we keep it simple.
let me add to that, because I will tell you that I regularly tell my clients that you should have two separate files anyway. You should have the personnel file and the confidential file. The personnel file is where you keep the application and performance evaluations and corrective action and anything else that doesn't contain what I call protected information. And then you have the confidential file, which has everything from your I-9 forms to your affirmations, which can be kept in separate sub-files so that when Peter and his team come calling, you pull out the state affirmation file, he gets that. Or if ICE comes calling, you pull out the I-9 sub-file, and they just get that. Out of the confidential file, which also has things like medical enrollment forms, requests for medical leave, documents that disclose somebody's disability or other protected status, their ethnicity, for example. If you have a form where people are self-identifying what their ethnic background is, that's protected information as well. And so that ought to be going into the confidential file that is limited to only those with a genuine need to know that sort of information. A more select group than those who would have access to the personnel file, which is, your supervisors who are using that to complete performance evaluations or to fill out corrective action forms. So those things ought to exist already in your workplace without either Peter or his counterparts at the Federal Department of Labor telling you that you need those.
Okay.
Okay? I just think it's a really good, not only is it a best practice, but also it will save you from a lot of the sort of parade of horribles that Andy was going through, which is if it's all in one file and you hand over that personnel file, you may be completely clean on a particular issue, but the auditor or somebody else notices something else in that file that piques their interest. And so being able to segregate that and give a limited disclosure of information to whoever's peeking into your business can be a very helpful thing. It's sort of the less is more approach to that appearance of cooperation that I was talking about earlier.
Okay.
Yeah. And the second question was just why were we going towards more of an enforcement, fine, penalty, that kind of model? And the simple answer was the legislation that was passed in the last year that's become a trend in the country, but frankly, there was just a view from the proponents of the laws that my division didn't necessarily have the tools to enforce the law in a fair but strong enough way, and that the court system wasn't necessarily equipped to handle these, so they just wanted to give us more tools.
So they wanted you to be the enforcer as far as that. And just a little sub question on that one then, because I know I'm going to run into this here in a couple weeks. You have that 14-day period for a penalty when someone says a demand for payment, and we have to hustle up and do everything and drop everything and get that done within that 14 days. But then when that employee is proven wrong, there's no kind of backlash towards them with that, particularly with this Facebook part that you were talking about earlier. If you fire somebody because they are bad-mouthing your company online and they're an employee of yours, is that going to end up being a free speech type of thing that they can say whatever they want, but we can't go into their Facebook and look at it, but they can go onto ours?
You just covered about like 5 different employment laws that apply here. But the answer is, if employees are complaining about anything that could be classified as a term or condition of their employment, they get to do it, even if you think it disparages your company.
Yeah.
And one of the questions I would have is, how did you find out about it? Because there's the Houston's case where owners and supervisors gained access to Facebook accounts, found out that employees had been bad-mouthing a supervisor, canned those employees sued and won for wrongful discharge and invasion of privacy. So you got to be careful about gaining access, and then 2, with what you do with the information. So the sort of learning point here is be very careful about what you do when you find out about that information, because there's this other federal law, which is the subject of a seminar for another day, called the National Labor Relations Act, that's been around since the late 30s, that has always said that employees have the right to get together and essentially bitch, moan, and complain about their terms and conditions of employment, even if that has a negative connotation to the for the employer. And it's protected, and if you fire them for that, you've committed an unfair labor practice, and they can come after you within 6 months for that unfair labor practice charge and get reinstatement and back pay. So anyway, that answers one of the questions that you were posing.
Yeah.
In terms of that 14-day demand, if there's no merit to it, you know, they make the demand, you do your due diligence, and you figure out within the 14 days that nothing is owed, you're right. There is no backlash. I call it no deterrent or disincentive for them doing that. Even if an employee is doing it to bust your chops, I don't think that there's any way for you to get, for example, your attorney's fees just for that. Now, you may be able to get your attorney's fees if they sue. I don't know about under the administrative procedure, whether there's
Our
any
administrative
basis.
procedure, we do not award attorney's fees to either party. So that could occur in court, essentially, if you prevail.
It used to be that, I'm sorry, I didn't mean to interrupt you. It used to be that the Wage Claim Act had this wonderful language called whoever the winning party is, they get their fees, and so whether it was employer or employee, whoever won got their fees awarded. But it was a blood from a turnip problem anyway, because I'd get fee awards against employees, and there'd be no way to collect. So you'd have liens on houses, and I had a guy come to a deposition, and he had on a really nice Rolex. That's how I got my client paid, was he had to pay his fee award with his Rolex. And so we had to build up a settlement agreement based on, okay, you're giving my client this Rolex, and we're going to treat that as covering the fee award. And it got to a point where it was so absurd that, frankly, it was hard to enforce anyway. But now there's language under the statute that if the employee says you owe them 10 grand, but you really only owe them 5 and you pay the 5, and they don't recover more than 5 in a lawsuit, that technically they have to pay your fees, you still have the blood from a turnip problem. Yeah, well, if they were in a Rolex, you might be able to. All the way in the back.
Okay, this is about the social media law. Is it okay to have a Facebook page for employees to see promotions that are going on, trainings that are going on, updates that's just for the employees?
Sure, and you know what this law is designed to do.
Question.
Oh yeah, and the question was, can an employer have a Facebook page that deals with company matters such as promotions and new jobs and postings, things of that nature? And in general, this law that I was talking about, this unique state law, is just solely focused on the employee's personal private accounts. None of this law prohibits an employer from doing things they want with their own accounts, their own social media. And I know there's not this bright line. A lot of companies and employees kind of, may share accounts or have other unique relationships that may not be clear-cut under this law. But in general, employees can have what you described as long as that's not the employee's private social media account.
And then also, do you recommend having an employee handbook about social media policy?
So the question is, do we recommend having a social media policy and handbook? And the answer to that is yes. Especially where there is, social media is being used for business purposes, and sort of drawing the line between, well, there can be different types of social media policies. There's one that addresses that circumstance. The other one is, not using social media in a way that violates your anti-harassment policy, for example, or using social media in a way that defames employees or the employer. That's not protected conduct. They can't lie about the company. And so, you can build in, I call them electronic communications policies that deal with everything from your fax machine to your computer systems to social media. And you can spell all of that out, but you want to also be very careful to point out that, you recognize as an employer that employees have the right under Section 7 of the National Labor Relations Act to get together and to talk about their terms and conditions of employment. Nothing in your policy is designed to infringe upon those rights. It's called a Section 7 disclaimer. And generally speaking, the National Labor Relations Board will enforce, or at least not hammer you if you have one of those disclaimers built into your policy.
Can you tell or direct employees what percentage they should tip, like the busboy or the bartender?
It's sort of a tip sharing arrangement?
Well,
Tipping out.
Tipping
Yeah.
out the busboy, tipping out the bartender. Can you tell them, okay, the bar gets,
Yes.
12%?
Yeah. So the question is, can you direct a server on how much to tip out? And the answer to that is yes. And oftentimes your tip credit and tip pool memo or tip sharing memo will spell that out. But you want to make sure that you are truly spelling that out and that number isn't changing unbeknownst to employees, or they're not being provided notice of how that process works. Because if you change it, I think you're exposing yourself to claims by a plaintiff's lawyer that you have an illegal tip pool.
And that individual must be a tipped employee.
Right. Customarily and regularly receive at least $30 a month in tips. So the lady in the gray sweater first.
Along the same lines, so I'm going to be running a food service restaurant, so I won't have tipped employees. It'll be paid minimum wage.
Okay.
Similar to like a Starbucks or something. If there is a tip jar and somebody does put money in there, are there restrictions on who can share that? Obviously, I wouldn't, but can the person who's cooking food and
Right. So the question is, in a restaurant that doesn't have a tip pool, and there's I'm sorry, let me back up. In a restaurant where you're actually paying minimum wage, the full minimum wage, not the state tipped employee minimum wage, and there's a tip jar, can you use the proceeds of that tip jar to pay back of the house staff, with the example that you used, like a cook or, yeah. So by paying minimum wage, there is case law that says you can essentially do whatever you want with the tip jar. But there is also case law saying that if you use it to include owners or managers, that's still problematic. Okay, now this is federal law, this isn't state law. And so you can make sort of a calculated business decision to allow folks to share in that. I think anytime you allow managers or owners to participate at any level, you are asking for a plaintiff's lawyer to start poking around.
is there an assistant manager I considered?
Yeah, if they've got the word manager or supervisor in their title, whether it's assistant manager, assistant to the manager, whatever you want to call them, I think that you are asking for a plaintiff's lawyer to poke around. I just think, even though you may win that lawsuit, and you likely would, you've still bought yourself a lawsuit, and it's going to take yourself a while to get extricated from it, to get it dismissed. Is probably a better non-stupid lawyer word. I think you steer clear of it.
One thing to remember, I think, is that getting into the mentality of all of my employees love me and they would never take any action against me is exceedingly naive. That basically we need to do all of these things to protect ourselves against those employees who love you but basically decide that after you've terminated them, they do not love you nearly as much. We have some questions from folks listening. One is about the half-hour duty-free period. When working in excess of 5 hours, is the half-hour duty-free period for individuals below that, I assume. In other words, they're not working a full 5-hour shift. Is the half-hour still required? And not only that, but then we have a way in the industry of calling people back. They're on break, on the meal break, but 15 customers just come late and we have to call them back. Can we just pay that minimum wage for that half hour and not worry about it? Or do we have to somehow other ways go about it?
Well, the initial question looks like, you know, if somebody gets a duty-free period when they work in excess of 5 hours, do you have to compensate for that? And the answer is no. If it's duty-free, it's uncompensated. It's unpaid. If the employee is working less than 5 hours, you don't have to give them a meal period of any length because their work period is so short. So maybe that gets to the first question. And if they work more than 5 hours, you got to give the half-hour duty-free lunch period. If they work any portion of that, it is clear under both federal and state law that you got to pay for that. And then we have this wrinkle under federal law, under state law, which is that if it's impractical to have the half-hour duty-free meal period, that employee is entitled to the on-duty meal of their choosing.
But it doesn't specify that the employer is supposed to pay for that.
Okay. Oh, that's a really good point. Yeah, okay. So if they want lobster, they have to pay for the lobster.
Exactly. They get to eat what they brought, right, whatever that is.
Okay.
Okay. There are some more questions right in front of you.
Sure. One of the questions here, this is a wage hour overtime question regarding 12 hours per workday standards. How is a workday defined? And a workday is defined as a fixed and recurring period of 24 consecutive hours, and that's then added up 7 days in a row, meets your work week definition. So workday is defined by the employer as that fixed and recurring period of 24 hours. So it could be an instance given here, the example of midnight to 11:59. It is not defined by the hours that the business is actually open unless the employer wants it to be defined that way. And the second question I have...
So the employer has some control in defining that.
Absolutely. The employer defines the workday and the work week as long as it matches those mathematical definitions of fixed and recurring periods of time of 24 hours in a row and then 7 days in a row. And then the second question is, what's the best practice when an employee wants to update their IDs or verification for I-9s and affirmation standards? And the simple answer is under state law is that we're not looking for it to be updated, unlike I-9. So you may have to update your I-9s periodically. Once you do our affirmations and copy those documents within 20 days of hire under the Colorado law, you never have to do anything again with them until that employee is fired. So it's just that 20-day window. Don't worry about updating it, but that doesn't apply to I-9s. You may have to update I-9 information periodically.
Another question that we got online was, can vacation be use it or lose it so that employees would not be paid for prior years? And I'm going to let Peter speak to the work that his group is doing on this. I can tell you what the current state of the law is in Colorado, and that is that it's unresolved. You have some tension in the law right now, the tension being that one's entitlement to compensation, including vacation pay, is based on the written agreement between the parties. And there's case law as well as the statute that is very clear about that. And so that would suggest that if you want to have a use it or lose it policy, you should be able to have that. Now, weighed against that is another body of case law that says that forfeitures are disfavored by our courts in Colorado, and use it or lose it is a forfeiture. So when I say it's unresolved, that means that there is not a case in Colorado yet that has resolved that issue. Now, I don't know if Peter's group is going to attempt to resolve that sort of unanswered question, or if you even agree with me that it's unanswered under Colorado law.
I very much agree with you. However, our division is looking to put out more definitive guidance on this in the coming months and year that hopefully should clarify the division's position, and we'll ultimately see whether the court adopts that position or not. But exactly as Todd's saying, use it or lose it may be dangerous. Forfeiture clause is strongly disfavored, just as he said. So if you want to be safe, pay out everything earned in accordance with the terms of that agreement. You can certainly cap accruals. That's the way around this whole problem, is don't let them accrue anymore. Once they've used, reached a certain point, make them use it. Things like that are, business alternatives to these legal issues. But we hope to have written policies on that in the coming year.
Please.
I've got a couple questions. On off-the-clock work, where are emails and cell phones?
Oh, that's a great question. Okay, so let's do the first. Yeah, let's do the first question. So the question was, with off-the-clock work, how do email and cell phones or smartphones fit into all of that? And really, the only clear-cut way to avoid a non-exempt employee from being entitled to pay for answering email or using their smartphone for business purposes is to prohibit them from doing it. And when they do it, to discipline them for doing so. Because in some, there certainly is case law to support this, that if the employee is using the smartphone to perform the functions of his or her position, even if it's after hours, that can be compensable time that you have to pay for. Okay? So, for exempt employees, it doesn't matter. Right? So if one of my associate attorneys who's professionally exempt is answering phone calls after hours or responding to email after hours, doesn't matter, because that's part of their job, and they're exempt. But for non-exempt workers, that then becomes hours worked if they're using it to do their jobs. And so to have a very clear policy saying employees are not to use their smartphones and are not to answer email after their work shifts is probably the best protection that you can have, unless you want them to do that, in which case there's a good chance you're going to have to pay for it. Okay?
Okay, if I can just butt in for just a moment, we'll be back to you in a moment. We would like to end this session. For those of you that are on the webinar remotely, and thank you for your attendance, and we will stay, and Todd and Peter have indicated they will stay for a couple more minutes. So.
We'll stay until you're done with your questions.
Just real quick, we do want to thank everyone for attending both in person and on the webinar, and also to thank our series sponsor, Pinnacle Assurance. And make sure you mark your calendars for March 10th for our next session, where we'll be discussing allergens.
Okay, we're off.